All right, welcome back. This week we're talking about possession, which is the beginning of the book because it's an extremely important concept in the law of property, as we'll see. And that means both real and personal property. So land and stuff, right, which are the two categories that we'll look at this term. Generally, real property, as I said, is land, and stuff, right? Personal property is everything else. That's basically how it's defined, makes things pretty simple. Possession is important because it is, as we'll see, a means to acquire ownership, these being two different things. And you can see that from, right, your own personal experience. You might have the right to possess your apartment because you signed a lease for it. But that's distinct from ownership, and in that example, ownership is actually someone else's who has, therefore, the ability to re-enter the property when your lease is over, collect rent, all sorts of things. And that illustrates one of the things that we saw last week when we said that property is first a relationship, therefore ownership, right, is a relationship in that example, uniting the owner and the apartment building. And we also said that as a relationship, it's best characterized as a bundle of rights, as a number of rights that you can bargain away separately. So in that example, the owner, by virtue of their ownership, which is kind of higher in that hierarchy, also has the ability to possess the apartment. They're allowed to give that away. That's part of their property relationship, their bundle of rights. They give one away, that is the right to possess, and they give it to you, generally in exchange for money. That's generally why people are willing to give away their rights in the law. And you, therefore, acquire a property relationship. So they gave you a part of their property relationship, now you have one, namely the ability to possess the apartment. They are both property relationships, the initial one and the two remaining ones once it's been split up. So possession is, as I said, therefore, a property relationship. It is a relationship that gives certain rights and privileges to the person in a relationship to the thing, whether, again, that is real or personal property. As we'll see, possession is also a means to acquire ownership. So say someone loses their stuff and then you find it, you have possession of it by virtue of the fact that you took it, right? We'll see what that means. And as a result of that, you've acquired a property relationship to the thing, right? Namely, the right to possess. And as we'll see, that right becomes immediately opposable to all third parties except the owner, because of course the owner is still the owner even though they lost their stuff, right? They still have their own property relationship. Same thing as the apartment building there. So you find this stuff, right? Now you have possession, which, as I said, is a property relationship. Subsequently, you can acquire ownership by virtue of possession, namely, if the person who has ownership doesn't show up in time, and there will be generally a statute which will provide for what that time is, then you acquire not just possession but ownership. You acquire the rest of the property relationship that you didn't have, and in that sense it becomes essentially complete because now you have full ownership of that thing. And what you can do with that relationship is different. As I said, if you have only possession, that is opposable to all except the owner for obvious reasons. Once you have ownership, it's opposable to all, period. Unless, of course, you've contractually given away your right to possession, such as through a lease. So we'll see there are various ways to define possession. We'll see that as we move further along in the chapter. One of the things that you saw from my earlier explanation here is the importance of time, right? So you have first, say, the owner, right, in my example, then they lose their stuff, so you find it, and then say someone takes it away from you. We'll call them evil. Okay, so the owner has ownership of whatever they lose, and then they lose their thing, right? They still have, as I said, their ownership of the thing, which gives them certain rights, namely that they have the right to claim it, right? Because it's theirs. So ownership gives you a right to possession. That's one of the things, because it's the full property relationship there. Therefore, if you find out that someone else is preventing you from exercising that right, you can sue them because they've done something illegal under something called conversion, if it's a thing. Of course, to do that, you've got to know who it is, right? You've got to locate the person who has your stuff so that you can sue them and claim it. If you don't know who it is, you have no way to exercise that right. So say you don't know who it is because you lost your stuff, right? You don't know where it is. Then someone finds it. That person, right, you can't sue, and so they acquire a property relationship, as I said, different from the owner because it's not full ownership yet. They just found the stuff, right? The owner is still the owner, but that person has possession. And that possession will be true as long as the owner figures out who that person is who has possession. Therefore, that person has a quote-unquote possessory relationship, which, as we said, can eventually give them ownership, but initially doesn't. So they have a possessory relationship, which is a property right. And what use is that, you ask? Well, it's useful when evil person there subsequently takes possession, and finder disagrees. Well, if finder disagrees, he has a possessory relationship with the thing, even though it's not theirs. And therefore, they can claim it from evil, and all that is because of time. So the owner retains the right as against finder because they are prior in time, and they have ownership, title, and finder has certain rights against evil, even though neither of them owned the thing to start with. They both found it, right? Evil can be sued for conversion because if they take the stuff away from finder, assuming finder knows about it for the reasons I mentioned, then, right, they are interfering with that possessory interest that finder has, and therefore finder can sue for conversion as if they had ownership, because ownership also comes with a possessory relationship by default, as I said. It comes with other rights, but that's one of the rights. It's also what we call relativity of title, relative meaning that it is relative in time. Therefore, finder has rights, but these rights are relative in the sense that they are subject to the prior rights of owner, and therefore only opposable against subsequent tortfeasors, such as evil, who interfere with that relationship. So relativity essentially means the same thing as what I said, a relationship in time, and therefore a qualified or somewhat limited ability to exercise a remedy such as claiming under conversion. And as we said, usually there will be a law that provides for the fact that if owner hasn't located the thing, after a long enough period of time, it is lost, and therefore finder acquires ownership. That makes sense, right? You don't want owner to come up 60 years later and claim the thing. And that's basically the justification that's been used by the courts to justify it. First, we want things to be used in a way that is productive. So if you lose your stuff, that's not productive because you've lost it. You're no longer using it to the benefit of society by, say, right, creating various benefits from it, using your computer to be more productive, using your land to have crops, whatever it is, right? You're no longer making productive use of it. Therefore, society has an interest for the finder, right, to have some interest, some incentive to make productive use of it themselves. If they know that owner can show up any time and take it, they just won't try to make productive use of it, which we want them to do because now it's lost. And therefore, the law provides for certain rights for finder and also for the ability of finder to eventually acquire ownership. And again, Same thing there. Assuming it's land, most of the stuff this week is actually personal property. We'll see the rules are somewhat different for land, but let's use the example of land. Finder finds the land, right? That's being basically abandoned by the actual owner. Well, finder is going to be incentivized, as I said, to make certain productive use of it now that they have an ability to claim it against evil. However, they won't make full use of it. For instance, they might not build a house on it if they know that there is still a risk, however small or limited it is, that owner will show up 60 years from now and claim the land. And that's why we allow for finder to eventually, after a long enough period of time, also acquire actual ownership. Therefore, for owner to lose their rights entirely and for them to be vested upon finder, because we want finder to make full productive use of it. And in the converse sense, we want to punish owner for not having made productive use of their stuff by having been careless or lost it, for instance. So you have the two theories in the book that justify that, because of course, if you have something as simple as possession being the root of title potentially, it can lead to all sorts of scary things like colonization, right? So what is the justification that's been used for that? You have the two theories in the book. The first one is what they call labor theory, and the second one is social consent theory. Labor theory meaning you have made a certain effort to find the thing. So assuming it's a thing, assuming it's lost, you've made a certain effort to take it, and then you've made a certain effort to assert your dominion over it, right? To show everyone that you intend for it to look like it's yours, and therefore that investment of your time, of your labor, should be rewarded in law by giving you certain rights, namely possession and subsequently potentially title. And my explanation is actually better, even though I didn't write the book, right? We also want you to make productive use of that, right? And that is both an investment of your labor and therefore something that we want to reward. Social consent theory essentially means that you want your rights to be known to everyone. And so all that is important because possession does not just mean actual physical possession. It is not sufficient. So it does require that, right? So physical possession. But it also requires something more, kind of like intent. And so we don't just want you to take the thing physically. We want you to take the thing physically and do that in a way that is consistent with the thing, the right that you are potentially acquiring, namely the right to possession. And so we want you to take, for instance, the stuff that you found on the street, right, such as a wallet, and by your, say, subsequent conduct, you will show that your intent is to possess it. Namely, you won't give it away or abandon it yourself. If you do that, then the mere physical act of possession is not sufficient. Same thing for real or personal property. We want you to have, right, we want you to have something to show that, that you actually intend to first acquire a possessory relationship and then subsequently potentially ownership of the thing. You have the case of Pearson v. Post, which is a very old English case, like most of the ones in the chapter. And basically you have someone hunting, and then they're about to kill whatever animal it is, and someone shows up unexpectedly in a very impolite and unusual way, per the customs of people who hunt, and kills and takes the animal. And that person is found to have, even though they were rude, to have the relationship with the thing, even though they took it. Essentially, the first hunter in that example did not show sufficient physical control over the thing in a way that showed the intention. So if you kill it and you take it away, then you have both physical possession, control, dominion, whatever you want to call it, and the intent for that to be opposable to all. And that is rooted in social consent theory, namely that we give you these rights as a society, whether that's by virtue of the common law as made up by the courts in England 200 years ago, or by virtue of a statute passed by the legislature in the Ontario, right? Regardless of what it is, the law, which is all of us by virtue of our consent, provide you with certain rights, namely possession and subsequently potentially title. And therefore, we expect you to make your intention clear. We expect you to exercise possessions. In that example, you kill it, you take it away, then everyone knows, right? If someone wants to say, no, you're wrong, it's mine, then they can do that because they have constructive knowledge. They've been told indirectly that you intend to have dominion over the thing. So if it's lost, for example, we want you to take it away in a way that's clear, such that someone else can come in and claim it if that's what they want to do, a member of the society, which gives you the right to eventually, again, acquire title in the first place. Animals, this is not something we'll get into, but one of the problems with conceptualizing things as either subjects or objects of rights, namely individuals who own things and things which are being owned by individuals, is that some things don't fall neatly in that categorization, right? For instance, animals have to be characterized as either things that can, or individuals that can own things, or things that can own individuals. They're not characterized as individuals, and therefore they're things, right? Even though they're sentient beings, and even though we don't want you to have full dominion over your animals, you would your house. For instance, we don't want you to have a cruel attitude to your animal, and therefore the law is sometimes going to come in to kind of regulate that, but by default it remains that an animal is a piece of property with all the risks that that entails. It's also significant under tort law, which is probably something that you either have or will see shortly, because you are responsible in tort, in extra contractual liability, when things go wrong for stuff that you own. So if you have a building, a piece of it falls on someone, you're responsible for that as the owner of the building. Same thing for an animal. You are responsible for the act of your animal. If it injures someone, that is attributed to you, and therefore you can personally be sued for that, and the person can claim damages from you. So then you have the cases that deal more specifically with personal property. This is the general concept. As I said, this week we'll mostly look at personal property as opposed to real property, so stuff, not land. And more specifically, we start with lost objects, which are the simplest thing because you can wait for the owner to assert their ownership, but you know that by default they won't, and therefore it's likely that finder will eventually acquire title over the thing. So we'll impose certain obligations upon the finder to make a reasonable effort to find the owner and to take reasonable care of the thing in the meantime, but we will allow them to eventually acquire title, and that seems to be a good social choice because it's unlikely that owner will show up all of the time because they lost their stuff. So you have a number of somewhat important cases. First, you have the armory case, which is the kid that goes into the jeweler, and then they have the thing evaluated, they ask for it back, and then the evil employee of the jeweler does not give them the entire jewel back, and therefore, right, takes it away and profits from that. The facts are not important. Essentially, the kid still has the right to it. What is important is the assertion that, that's made in the case, essentially the ratio that the person who has possession, even though they're not the owner by definition, can assert that right against all but the rightful owner. So I said that already. If you find something, you are not the owner of it. You have a possessory relationship, which is a property relationship, as we said, and that property relationship can be asserted against evil, someone interfering with that relationship, for instance, by taking it away from you without your consent, and, in fact, any other person except for the rightful owner, because they are prior in time pursuant to relativity of title, as I said, and therefore they retain, at least for a certain period of time, their ability to claim it because they retain ownership. And so you only have a possessory relationship. Owner still has title to the thing, which is also a property relationship. Same thing as if you had entered into a lease, for instance, right? It's the exact same thing there. Someone has possession, someone has ownership, and therefore that person can claim ownership. And because you did not get possession, quote unquote, in a way that is legal, or at least with the consent of owner, as you would have if you signed a lease, owner still has the ability to claim possession from you. You only have the ability to claim possession from everyone else. That's the ratio in the case. You can exercise that property relationship against, quote, all but the rightful owner. That's what that means. And the court also finds, not that relatedly, that essentially there's tort liability for agency relationships. Again, it's something that you either have learned or will learn soon in tort law, but people or companies are also responsible for their employees because that is an agency relationship. They exercise control over their employee. They get a benefit from the work of their employee, namely that they get labor, and usually that's worth more than they pay for it, right? Otherwise they wouldn't make any money, and therefore they have to bear some of the risks of that relationship. And so if the employee goes and does something wrong, the employer has the liability for that, and therefore, in that example, the shop owner would have been responsible for the actions of their employee who took the stuff away from the kid. I won't get into the specific tort actions because it's not that important, but you have trover and conversion, and we won't get into the distinction there, but essentially that is the ability to claim possession back from someone who interfered with it. So if you have as a finder a possessory relationship, namely a right to have possession of the thing, then if someone interferes with that, namely takes it away, right, then you have a right to claim it back because you have it in the first place as a right, and that person doesn't. They're interfering with your rights and doing so in a way that is unlawful, right? They don't have any rights, and they therefore act in a way that's inconsistent with yours. Then you have the Parker case, which is really a way for the authors of the book to introduce all of the interesting case law from hundreds of years ago in England. So you have lots of other precedents which are important in there, but essentially you have an airport lounge. Someone loses something there. Someone else finds it. They're there legally. They are not a trespasser, so they were invited into the lounge, right, by the people who own it. I think it's an airline company, British Airways. And they find the thing. And then they give it to the lounge people and saying, if you don't find the owner, send it back to me because I found it, because I have a possessory relationship, which I've, by virtue of having found it, which is conveniently opposable to all but the owner. And therefore, right, you, as that person, you can claim it unless the owner shows up. And even though you give it to someone else with consent. So in my example, if you have something that you find, say it's a bag, and then evil takes it away from you, they've done that without your consent, and therefore you can claim that. You can claim it back because you have a possessory relationship. In my example there, if you give it to the lounge employees, you are not denying your possessory relationship. You're not saying I'm gifting it to you, for instance, and that employee is not either taking it away from you without your consent. You're giving it to them for a specific purpose in saying, I only want you to keep this if you find the true owner. If you don't, I want it back. And therefore, even though you no longer have possession, even though you have a possessory relationship, but you are now no longer in possession, you retain that possessory relationship because you did not abandon the thing. You gave it to someone with conditions. And these conditions do not deny that you have a property relationship. Right? In fact, you said, unless you find the owner, I want it back. In other words, you define the relationship that you have in law pursuant to the case. And therefore, by giving it away with these conditions, you did not lose your possessory interest to subsequently claim it, even though you are no longer in physical actual possession. So what happens there, of course, the lounge employees try to keep it even though they don't find the owner. In fact, the airline company tries to do that. And what do they say? They say, well, it was found on our property. The lounge is our property, and therefore we also have an interest. That person has a possessory interest by virtue of the fact that they found it, but we have an interest by virtue of the fact that it's on our property. And therefore, there ought to be a presumption that it's ours. And therefore, even if we recognize that the person also has a possessory relationship, we are prior in relationship pursuant to relativity of title, because it was on our property before, in time, that person found it and therefore asserted a relationship to it. Court says no. Therefore, the ratio of that case kind of is that, right, the owner of the premises does not have a possessory relationship, not one that is opposable to a finder. So if you find something upon someone's property, it's still as if you found it on the street when it's been abandoned. Of course, if you break in, it's going to be a different story, but to the extent you're somewhere you have a legal right to be, and in that example you are, right? The passenger who finds the thing is in the lounge legally, right? They didn't break in, they were invited, and therefore they can claim a possessory relationship to what they found, even though someone else owns the place where they are. You have a number of other cases, as I said, which are mentioned there, which are important, including the Armory case and some of the case law in which it's subsequently developed. And the same tort law principle is going to apply there. So the employee in that example who takes the thing, to the extent that they do that within the scope of their employment, in that quote-unquote agency relationship, as I said, they therefore cannot claim it themselves. They can't say, now, I'm the one that it was given to, and therefore I have a possessory relationship. That relationship is attributed by virtue of agency to their employer, namely the airline, and therefore, right, the airline acquires the rights that would otherwise have been acquired by the person if the airline has succeeded in proving these rights. Then you have page 112, the important stuff, which is basically what I said. You have all of the distinctions there which are important. The first one is, if you find something you acquire, the ability to assert your possessory relationship against all but the true owner. Then you have the distinction that we said, which is that if you find it on someone else's property, to the extent that you're there legally, it's still yours. Then you have a number of other obligations that come by virtue of that, the main one being to find the person and to take care. So these are your obligations as a finder. So you find something, you acquire a possessory relationship, it is a lost object. So you find an object, personal property, not real property, you find it, it seems to be lost, then you acquire the ability to claim that against all but the rightful owner. If you find it somewhere, the owner of that somewhere does not have rights that are superior to yours. You do. And you have two additional obligations there. The first one is to make a reasonable effort to find the rightful owner. That kind of makes sense, right? We don't want to reward people who steal stuff, and we also don't want to reward people who find stuff and then don't try to give it back, right? We just want to reward them if they've been honest, and part of being honest means trying to find the rightful owner. And you can do that in a number of ways. Generally, the way you do that is call the police and say, I have found something, and I want you to look for the rightful owner, whether that means giving the stuff to the police in the meantime or not, depending on the circumstances and your specific legal obligations. Second one is to take reasonable care of it, kind of similar to what we call a bailment. So if you give someone something for a period of time that is yours, usually that person has an obligation to take care of it. And oftentimes they'll get paid for that. So if you park your car in a garage while you're on vacation, you pay for that, and the person has a correlative obligation to take reasonable care of your car to make sure it doesn't get destroyed, and therefore that you lose your essentially your title because your property isn't worth anything anymore. Same thing there, to the extent that you still are subject to the rights of the owner, you're expected to take reasonable care of the thing so that if the owner shows up, the thing is still as they have lost it, or at least as close as it can be to that. There's also the agency relationship, as we said. If that's done within the scope of employment, then it's attributed to the employer. And you have the obligations that we discussed. Then you have a distinction that's often used when you have both a thing and a building. And it's detailed in more detail again at page 112, as I said. And you have these same obligations as you would, right? So if you find something somewhere, but it's attached to a building, you have all these same obligations. However, the rights of the owner of the building are different. So say, so say all of that works if you find something that's been abandoned, say it's lying on the floor somewhere or on the street, but as we said, the floor is the same as the street to the extent that you're on the floor legally. However, if the thing is attached to a building, you have the opposite presumption. And so we said that the British Airways people couldn't come in and say, we have a prior possessory interest in the thing by virtue of the fact that it was abandoned on our property before someone found it. If it were something that is attached to the property in some way, then it would be the opposite. Then the owner of the building could make that claim, subject to all the obligations that we discussed, right? Same thing. However, the owner would have a presumption that they have prior possessory relationship as against the person who detached it and took it away. sometimes, as the owner of a building, you will show your intent to exercise control in that sense, in the sense of physical possession, by limiting the number of people who can show up on your property. And in that sense, you can have a prior relationship. So say it's your house, right? Or even if it's an airport lounge. Let's say it's an airport lounge and you have a very limited number of people who can come in, and you have a very stringent policy where you have an employee who spends their entire day looking for stuff. Then you've shown an interest in finding it, and therefore an interest in demonstrating physical possession and control over stuff that you have yet to find because you're looking for it. And if you do that, then you might be able to show a prior possessory relationship to the person who finds the thing, because you exercise control even though you haven't found it, right? By having an employee actively looking for stuff all of the time, then you might have, right, shown your intent to exercise control over the lost thing before the person who subsequently finds it. Then there's an issue as to what happens when you have multiple people who find something, right? Obviously, if you have 3 people who are all trying to walk down the street and they find something, or they're looking for it and they find it, then it's not that hard, right? You just split it into 3 and they all have a right to it. Oftentimes, it's going to be more complicated than that, right? So for instance, you'll have each person do a part of what is necessary to eventually find it and subsequently exercise sufficient control over it. And therefore, it's not going to be clear what their relative contributions are. And oftentimes, the person who finds it, right, even though it's based on someone else's effort, will claim that it's theirs entirely. And they have an incentive to do that, of course, because they don't want to share it, right? Generally, the law is going to say what I said. So if everyone contributes, everyone gets a share of it. And oftentimes, that's going to turn on the factual evidentiary burden of the people who actually show up in court. So what do I mean there? Oftentimes, you'll have conflicting stories. So you've got 3 people. One of them says, right, I found it. Someone else says, I found it. Someone else says, right, neither of them found it. I actually found it, and they took it away from me. Then you don't really know what happens, and to the extent that you don't know what happens, you'll just have the default presumption that it's been found by all 3 people, right? By virtue of the fact that you know that they were all there, you don't know what actually happened specifically because you've got conflicting evidence, right? The fairest thing to do, and the most consistent with the facts that you do have, namely that they were all there, is to just act as if they found it together. You don't know what actually happened, therefore you split it into 3, which is the default presumption, as opposed to having one person getting a greater share of it because they've shown that they found it alone or that they had a greater contribution to it. Same thing there, right? You have in the Karen case, page 118, you have a bunch of kids playing with something that turns out to have money in it. One of them found it, of course. So he's going to say, I found it. But when they found it, that's what the court says, and it makes sense, they did not know that it was money. If they did, they would have shown it by not sharing it with the other kids to play, and therefore they could have claimed full possessory interest over it. In that example, they didn't know that it contained money, and therefore they had the other kids play with it, and then subsequently it turned out to have money in it. Then all the kids found the money, because when the first kid found the thing, it wasn't with that intent, and subsequently when they shared it, it wasn't with the requisite intent. For instance, if they knew it had money in it, if it were a wallet, they would have been far more careful in letting the other kids play with it, right? They would have said, I am only giving you this subject to my legal right to claim ownership over it because I want the money. It's not what happened, and therefore all the kids found the money. Then you have another case which is important, the Popov case on this very important baseball that someone tries to catch. And then, of course, if they catch it, they do the thing that they're supposed to do there. They demonstrate control, they acquire physical possession over it, and with the intent to keep it, right? So they catch it, and then it's clear that it's not to give it to their neighbor there. It is to keep it for themselves because it's worth a lot of money. But what happens there, as the person is catching the baseball, they get attacked by an angry mob of people who also want the baseball that's worth $500,000. Of course, then we don't want to reward the people who attack them, because that person did not find a lost object in a way that is peaceful there. They found it, then they exerted dominion over it with the intent to have the requisite, right, the requisite intent to exclude people and eventually acquire ownership over it. People there are more like evil. They took this stuff away from the guy. The guy is a peaceful person who acquires ownership peacefully and then gets attacked, and that's not something we want to reward with a possessory relationship. And so we won't give the mob, even though they eventually take it, the right to have it as if they caught it in the first place. It's basically what the case is going to say in a far more complex way, because then the court has to kind of make up the rules there because they don't exist yet. So why is that a problem? Well, if someone catches it, you've got to see the timeline there again, right? So it's something that is being abandoned. It's being given away, right? So it's knocked out of the park, and then with the intent that someone will catch it eventually and therefore gain, right, both a possessory relationship and eventual ownership. The person there is like finder. They catch it with the intent to have it forever. However, it's not as clear in time that you have a subsequent interference with that relationship. So in my example, I said finder finds it and then say 2 days later, evil comes in, takes it away from them without their consent. Then they claim it back, right? So they say, someone interfered with my legal rights. I want it back pursuant to my possessory relationship. What happened there, it all kind of happened at the same time. So it's not clear if the person who caught the baseball had already shown sufficient physical dominion over it to claim it against subsequent people, namely the evil people who mobbed him to get the baseball. Because they did not have full physical possession over it. They caught it, but then lost it, right? They did not have time to acquire full physical possession over it. But the court is going to say that that's sufficient for the policy reasons that we have, right? And that's legitimate even in 19th century England, because you had something called equity, right? So you had the common law, which were the rules that were developed by the courts over a very long period of time, and then subsequent precedent has to follow the rules. So judges in subsequent cases have to follow the rules because they've become rules because they've been applied enough times to become rules. You also had the thing called equity, where you could go to a court and say, this ain't fair, right? I want this to be fair, and it's not, and therefore I want justice to be served even though I have no claim in law. Your claim is, right, I have no ability to make a legal claim for it in an actual court of law because the law is not on my side, but justice is. It ain't fair. That's equity. And so the courts have both powers, right? They were merged in common law history, and therefore they have the ability to give equitable relief. And that's still true today, right? For instance, if you have people, they get married, they don't sign a proper contract, and then the guy makes $20 million, the wife only has $50,000. That's not fair. Well, each own the thing, right? Each own their bank accounts, and they don't have a claim to each other's assets by virtue of the law because they signed a marriage contract. What's the court going to do? It's essentially going to exercise its equitable power. It's going to make stuff up. It's going to say, we have a constructive trust. We have a trust being when someone holds something for someone else, that's a trust relationship, right? We'll say that the man, as he was getting the $20 million, he was doing that half on behalf of his wife, who was clearly contributing to the enterprise, and therefore, even though he owns the shares are actually owned by a trust of which the wife is half owner. And you see that is not legal, right? It's not based in law, it's the courts granting equitable relief. So creating justice where the law does not serve it. So the court's going to do that there, and it's going to grant equitable relief by saying that the guy, Mr. Popov, who caught the baseball, had a prepossessory interest, namely an interest that they just made up. Because I said finder has a possessory interest. So if you catch the baseball with the requisite criteria there, you have a possessory relationship, namely the ability to claim possession against all but the rightful owner. However, the guy didn't meet the criteria there. So what do they say? They say he had a prepossessory relationship, namely a relationship that allows him to claim possession of the baseball as against the people who mobbed him, and subsequently then he has a possessory relationship, and it's as if he caught the baseball in the first place. There's a bit of a complexification there in that after he got mobbed, the ball got lost, and then someone else found it, and then it wouldn't be fair for that person to not have it, because that person was just as honest and found it in the same way as the guy who caught it, right? However, they only were able to catch it because the guy was mobbed, so the court just splits it in half. Doesn't really change the principles I just gave you. Okay, then you have one last case on basically the same principles, which is the Bird case. And what you have there, you have a kid against who finds something that turns out to have money in it, right? Seems to be a recurring pattern in our cases there. And then usually you have someone else claim the money. So what happens, the kid crawls under a building and finds a can full of money. This is not the same thing as if they just found something, right, that was lying there. They had to crawl under it and take it. And by default, you would expect the owner of the building, from the principles I mentioned, to have a prior possessory interest, because the thing is ostensibly, it's not that clear in that case, but ostensibly, most likely, counts as attached to a building. And therefore, if the kid got sued by the building owner, and the building owner says, I have a prior possessory interest. You have a possessory interest because you found it. I have a prior possessory interest because I own the building and it's attached to it. As we said, the owner of the building would win because they're correct. However, it's not what happens there. The building owner is not the person who sues. And so it doesn't matter anymore. Right? The building owner would win because they're right. However, to the extent that the finder, namely the kid, is being sued by someone else, the kid will win. Because again, the kid has, right, the ability to claim their possessory interest against all but the true owner, namely all but the person who's not suing. And what happens there? The kid gives it to their mom. That's going to be perhaps a problem, right? Same thing as the airport lounge. Then the question is whether you gave up your interest voluntarily and therefore are no longer able to go to court and claim it, or whether you simply gave the thing in a way that was not inconsistent with your rights. So we said when he gave it to the lounge employees, he gave it with the specific instruction that he wasn't waiving his rights, right? He basically described his relationship as it exists in law. He says, I want you to give this back to me unless the owner shows up. And therefore, that person did not waive their right when they gave it to someone else, because they gave it to someone else in trust. They entrusted it to them, so that person holds it on their behalf, again, a trust relationship, and therefore they still have a possessory interest even though they temporarily do not have physical possession, because this is necessary to acquire the interest. So physical possession and intent is necessary to acquire the interest. But then, it's not as soon as you lose physical possession that you no longer have a possessory interest, because you also have intent. And if you give it to someone else without the intent to lose it, you still have a possessory interest in it. Same thing there, that's what the court finds. Court finds that when the kid gave it to their mom, they didn't abandon it. They basically made a legal claim there. They gave it to the mom and said, I'm just giving it to you because you're my mom, not because I want you to have it. And then you have a police officer come in, they take the stuff, and then the police officer ostensibly says, I will simply keep it until I turn out to know if I will find the owner or not. But then the police officer gives it to the tax man, even though they did not find the rightful owner. And what does the court say? The court says the kid still has a relationship, a possessory relationship, because they did not give it up when they gave it to their mom, and they did not give it up when they gave it to the police officer. And as we said, it's important to keep in mind, of course, that all of that might have been different, and in fact would have been different, if the person suing were the building owner where the kid found the cash in the first place. And that's also why, which is something we definitely won't get into, that's also why the kid is able to keep it even though they did something that might be illegal. Even though they did not ask for permission when taking it away, which might be illegal, but we don't decide not to reward that specifically for that reason, right? Specifically because the kid is not being sued by the building owner, who would have an ability to make a similar claim. And one of the ratios that come out of the case are what I said earlier. The kid, right, same thing as British Airways, they are Parker. The kid, by virtue of giving the thing up to someone else, subject to specific conditions, does not lose their possessory interest. And that makes sense, as we said, because usually they only give up physical possession and not the intent to keep their possessory relationship. And I said at the very beginning of all this that you can eventually acquire actual ownership. And so when you find something in all the ways that we discussed, you take it subject to the rights of the rightful owner. You acquire possessory relationships subject to the fact that someone else holds title, someone else has actual ownership of the thing that you found. And I said, eventually, the rights of the owner are going to vanish, and they're going to vest upon the finder. And so possession is a way to acquire ownership. So that is true, in the context of what we call first possession. When there is no prior owner, it's not complicated. For instance, you kill an animal. The animal is up for the taking. According to the common law, it is in the commons, and therefore, when you acquire proper physical possession with the requisite intent, you acquire then ownership, because there is no prior owner of it. It's up for the taking. When you take it, it's yours. In the example of someone who loses something, there is a prior owner whose rights are not extinguished immediately upon losing the thing. And so we will wait for a period of time for them to show up. As I said earlier, we don't want it to be too long, because if it's too long, we won't encourage productive use of the property. Productive use of the property means looking for the stuff that you lost without waiting for 50 years. And it means being able to build a house on the land that you got without worrying about the rightful owner coming in 50 years later, right? And therefore, if you're worried about that possibility, you won't build the house in the first place. And so we have something called a statute of limitations. A statute of limitations is something that extinguishes a right that you otherwise have. For instance, the prescription period, as we call it, the period after which you lose your rights, is generally 3 years. And so, if you have a right, someone steals your money, you have 3 years to sue them, even if you're right. After 3 years, even if you're right, we don't allow you to sue anymore because you waited too long. Same thing there, right? We don't want to encourage people to sit there because that creates uncertainty, and therefore does not lead to productive use of property, because people have to always worry about someone coming in, because sometimes they might have done something, not know about it, right? We don't want them to worry about that for 40 years. And there's also other issues, for instance, having to do with evidence law. So if you get sued by someone for something you allegedly did 20 years ago, you might very well be right in saying that it's not true, but you won't have the documents to show it because you don't keep your documents for 20 years. So it wouldn't be fair, you wouldn't have a proper defense. Lots of reasons for that, but basically extinguishes a right that you otherwise have. So you have a right to claim in extra contractual liability if someone hurts you. You have a right to claim if someone steals from you, whatever the right is, but that right only exists for a period of time until it's extinguished by prescription pursuant to a statute of limitation. Same thing there. We'll say that the ability of the owner to claim their stuff out of the hands of the person who found it is extinguished upon a certain period of time. And then you'll recall there's the thing that we discussed called first possession, where basically the person acquires that ownership. The person who finds it eventually acquires that ownership. And there are also circumstances where you might even acquire something when the person knows about it. We'll see that with land, and it's what we call squatters' right. You might show up on someone's land, and you might know that it's not yours. So not the same thing there as having lost something. You know that it's not yours. And in fact, in all provinces, there's a land registry, so you have a way to know that it's not yours, and you have a way to know who it is. And that is adverse possession in the sense that you're being evil to the actual owner, adverse to their interest, and in some circumstances will even allow you to get ownership, again for the same reason. We don't want people to sit on their rights. We don't want the guy who owns the land to not show up there for 20 years and look at whether someone has taken possession of it illegally, and therefore, right, we reward productive use of property by rewarding the person who has, in that example, taken possession of the land, even though they did that wrongfully. And that creates a bunch of other more complicated situations, which is why all these principles are going to be relevant when we look at real property, so land as opposed to personal property. It's going to be slightly different because there's no such thing as lost land. As I said, there is a land registry. You can find out who owns it, right? So there's no lost land, and so we need different principles such as adverse possession. But the principles are going to be essentially the same in that possession is first not the same thing as title. Therefore, the fact that you show up on someone's land does not mean that you own it. The fact that you were renting an apartment does not mean that you own it. However, possession is eventually a means of acquiring actual ownership or title. And we'll look at that in a lot more detail next week.